Hi, my name is Chris Zona. I'm a partner here at Mandelbaum Barrett within our litigation, healthcare litigation, and white-collar criminal defense groups. With me is John Burns. John, why don't you introduce yourself?
Sure, my name is John Burns. I'm an associate here at Mandelbaum Barrett, handling commercial litigation and employment litigation.
So John, back in November, I was going through our website, which has a bunch of great information, a lot of great information for clients or potential clients about things that our attorneys are interested in. And one thing I noticed was that you wrote a very, very interesting article about some litigation related to the use of analytics in the NBA among two NBA teams, I believe the Knicks and the Raptors. Is that right?
That's right.
So for those of you who are watching, analytics are basically the use of statistical analysis in sports. If you're watching sports nowadays, you've clearly heard announcers talk about it, baseball, football, basketball. It is becoming a major way in which teams are analyzing their performance, but also interpreting how to actually call plays or to engage in plays. So John, really interested in this. Obviously, I'm a big sports fan. Why don't you tell us a little bit about how this case came to light and what exactly it relates to?
Sure. So the case itself really touches on a lot of different points. The New York Knicks had a employee who was working for them that handled various aspects of video analysis and other technological applications to their strategy. And that employee left to go to the Toronto Raptors, who is a conference rival, former NBA champion from 2019. And in the litigation itself, they're alleging that this employee took certain, what they're calling trade secrets now, related to their analysis of other teams, the plays they run, the amount of plays they run in certain situations, all the various aspects that, Chris, you just alluded to that are kind of exploding in the analytics in the sports world, where teams are no longer just relying on their own X's and O's strategies, but looking at that of other teams and trying to break it down in a computer model that gives them a benefit and edge for both their own strategy for in-game, their strategy for recruiting, college recruiting, drafting players of certain caliber, trying to get players in trades of certain calibers that hit on each of those statistical models. So essentially what the Knicks are saying is similar to a lot of employment litigation that we've dealt with here. You know, this person left with a trade secret and is feeding it to the Raptors and their coaching staff now.
So where are we in the litigation? Obviously, for us litigators, we know, and sometimes clients don't always know, but litigation has sometimes a very long lifespan. So whereabouts are we, and what caused you to feel like it was a good time to put an article out there and to discuss it?
Sure. So the complaint was just filed in August 2023. In October, in the Southern District of New York, in October of 23, the Raptors, was actually owned by the Toronto Maple Leafs parent corporation, filed a motion to dismiss in the Southern District, essentially relying on the NBA's arbitration agreement, trying to place the dispute itself back within the confines of the NBA and under the purview of Commissioner Adam Silver.
So let's talk a little bit. So when we talk about Southern District, so that's the federal court in New York, right?
That's right.
Okay. So can you tell us a little bit about what that means? What does it mean to be filing something to get back into arbitration, I take it? So obviously this case was filed as a normal court case, a normal complaint, right?
That's correct.
How would you help us understand where, like, you as an employment lawyer would come in a case in which it's filed as a complaint and trying to get it into arbitration? What are some of the pros and cons of being in one or the other forum?
Sure. So getting it back into arbitration kind of places it in a more controlled setting where I would imagine the NBA teams are more comfortable to try to air out whatever grievances they have, to keep it in a more private setting where you're not as like a litigation in the Southern District. It's a federal docket. It's accessible by anybody. It's public information. And, from the Raptors standpoint, it's a lot better to have it in an environment where they have a lot more control and perhaps even a more friendly arena with either the commissioner or his employees that are handling the arbitration.
And now you said the actual agreement is contained within one of the governing documents within the MBA. Is that right?
That's correct.
And that's much like if you're an employee out there, you might be entering an employee contract, and when you read that contract, you'll see sometimes there's an arbitration clause. Same thing for consumers or dispute resolution clause. Is it a similar type of function, even though we're talking about these multi-billion-dollar franchises? Is it still a similar sort of dispute resolution clause?
Yeah, as far as I understand it, it is something that would be similar to any run-of-the-mill arbitration clause where it places it in a more controlled environment. So one of the reasons that I wrote about this article is the fact that these issues don't just affect someone as famous as the New York Knicks and Toronto Raptors, but any kind of business that have standard non-competes and trade secret provisions in employment contracts. So we just want all of our clients and prospective clients out there to know that we're always ready and willing to assist anyone who's having issues in terms of an employee leaving with possible trade secrets or any other important proprietary information.
Thanks, John. Be well.